Canadians, the public has a right to know what happened. Recall that?
I do.
The Prime Minister promised Canadians when first elected in 2015 that they would see the most open and transparent government ever seen. Yet this inquiry has seen hundreds upon hundreds of redacted pages from the government with little explanation as to the legal basis for such exclusion. Would you agree that the actions of the Prime Minister and Cabinet Ministers who have testified at the inquiry have frustrated numerous lawyers in their ability to drill down to the truth as to the legal basis for the invocation of the Act?
I think that the Prime Minister and ministers being
Do you
on
agree
the
or not?
stand was extraordinarily transparent.
Do you agree?
I do
Madam
not
Chair, the
agree.
witness should
Thank
be
you.
allowed to answer the question.
Inquiry lawyer Gordon Campbell stated, "We have, from the beginning of this proceeding through till now, attempted to find a way to lift the veil that has made such a black box of what has turned out to be a central issue before the hearing. We just regret that it ends up being an absence of transparency on the part of the government." Do you recall that statement?
Not specifically, no.
Do you agree that Justice Minister Lametti testified at the inquiry that the government didn't use the legal definition within the Emergencies Act, but rather used their own reasons, but could not release it due to solicitor and client privilege? You're aware of that?
I did not see all of Minister Lametti's testimony.
You're aware that no government official, all the ministers and the Prime Minister, are talking about solicitor and client privilege as a basis for not releasing those legal opinions. You're certainly aware of that.
Solicitor client
Thank you.
privilege.
Justice Rouleau pressed Minister Lametti on this issue, asking how he would understand and pass judgment on the legal basis for invoking the Emergencies Act, which is a central issue in the Commission, when the government was not forthcoming on the legal rationale. He then said, quote, "I guess the answer is we just assume they acted in good faith in application of whatever they were told." Last question. Do you agree with me that the government response of just trust us, we acted in good faith when invoking the Emergencies Act is the complete opposite of being open and transparent with Justice Rouleau, but most importantly with Canadians? Do you agree with that statement or not?
Solicitor client privilege is a long-standing protocol in
Do you
this
agree with
country.
that statement, ma'am?
Solicitor client privilege.
Do you agree, yes or no?
I'm not answering that.
Thank you. I cede the rest of my time to my colleague.
Thank you very much, Madam Chair, and to my colleague. And just to the ITAC, would you agree that contrary to the suggestions from Ms. Bendayan, that there are individuals and groups that attach themselves to a protest and try to use that protest for their own ideological purpose? Would you agree with that statement? The suggestion has been made by Ms. Bendayan that the people in Coots were somehow protesters, but they were not. The RCMP has confirmed that.
Madam Chair, I never made such a suggestion.
Oh, you did. Anyway, Madam Chair, I'd like to take this opportunity for the time that I have left and beyond to move the motion that was circulated to the committee, and I will just advise that the intent is to briefly explain what it is for those who may not know, and to adjourn the debate on that until at a time next meeting.
Point of order. So I want to be clear through you, Madam Chair, procedurally, that the Mr. Motz is using his time, or is taking this time for the intervention to table or give notice, because if I'm correct, the correct amount of notice time prior to the meeting did not elapse, and therefore procedurally he can't table it and then adjourn it. Those are different things. Providing a notice verbally is one thing. Tabling it and adjourning it is another.
Mr. Motz, I believe that the proper terminology would be just to give notice. I thought that's what we had discussed.
Okay, fair enough. I will give notice that we'll table this motion, and here's the idea behind it. This
Mr.
committee-
Motz, I just, I'll stop. I just want to inform you of about 25 seconds left.
Yeah, but this is not part of my intervention. This is the moving of a motion.
It's oh, okay, pardon me then. I thought it was. Go ahead.
Thank you. An area of significant discussion that we've had at this committee has been whether the necessary threshold for the government to declare a public order emergency under the Emergencies Act has actually been satisfied. So the matter of the interpretation of those thresholds, including especially the so-called CSIS
Madam Chair,
Act
just on a point
threshold-
of order, I'm not. I believe Mr. Motz is explaining the rationale behind the
Briefly,
notice that he's
yes.
giving us.
Yes.
That's he's meant to be doing that during the remaining portion of his questioning time, which is apparently 25 seconds, according to what you just said.
I'm informed that it doesn't count in your question time, but I'm wondering, Mr. Motz, if you can make it as brief as possible since a notice of motion?
Absolutely. I'd be done already, have we not been interrupted so often, Madam Chair. The matter of the interpretation of these thresholds, including especially the so-called CSIS Act threshold, about what constitutes a threat to the security of Canada has lately become a central issue in the proceedings before the Public Order Emergency Commission. We will all recall that when the Attorney General was here of Canada, appeared before a committee on April 26th, he insisted upon solicitor-client privilege when questioned about these thresholds. In face of this claim,
Madam
on
Chair,
May
this is
31st,
not
our
a
committee
notice of
ordered
motion. This
the
is a
production of all
speech,
legal opinions
of
upon which the government
Motz.
determined.
No consequence to the witnesses before us. If he has a question for the witnesses.
Mr. Motz, can you wrap up the notice of motion, please? We can
Yes.
debate it next week.
I'm not debating it. I'm just simply introducing the motion or this particular motion that's going to be before us next week for those who might not understand what it is we're asking for. Transparency to Canadians is what I'm after here. Obviously, those who are opposed to this
Can
aren't
we-
anxious about transparency.
I appreciate. What would you continue, please?
Thank you. Evidence heard in the last few days at the Commission has made it clear that the government adopted for itself a broader interpretation of the CSIS Act threshold than CSIS itself employs to justify declaring a national emergency. The director of CSIS confirmed that this was done on the strength of a legal opinion prepared by the Department of Justice. The Commission's efforts to probe these issues further has been repeatedly stonewalled by the government.
Madam
Madam
Chair, I
Chair.
believe
Mr.
he's
Cameron
simply
remarked-
reading from a cover letter that he distributed to all of us. We've all got that letter. So if
This
that's
is-
the
this-
notice, then we don't need to be listening to this. We've got
It's
it.
not to you, Mr. Nakvi.
Then it can be discussed next week, as
And
we
Mr.
just
Varani?
agreed, Madam Chair. This is absolutely unacceptable.
Mr. Motz, can I just ask you to wrap up? I think you've got a fair bit on the record already.
Our committee is uniquely positioned to assist to get answers for both the Commission and Canadians, and the law of parliamentary privilege possessing a constitutional nature. Our committee and the House power supersedes
Chair,
statutory law
If you
and
have
other
made a
privileges.
ruling,
As
then
such,
it could be challenged, and I so challenge that ruling, Madam Chair. I do not understand what is happening to this committee. Reading a 2-page letter into the record does not constitute a notice of motion.
Mr. Motz, you're
I have one more
finished?
step. With the Commission's report being tabled in
Asking
less
you
than a
to
month.
finish?
Pardon me?
I'm asking you to finish there.
Yes. He is finished. Yes.
Okay, thank you.
I'm done?
Yes. I believe you've covered it. Thank you. Okay, well, Ms. 5 minutes.
Thank you, Madam Chair. Ms. Thomas, I'm going to start with you. Obviously, there's a definition in the CSIS Act about threats to the security of Canada. And in subsection C of that definition, it talks about activities within or relating to Canada directed toward or in support of the threat or the use of acts of serious violence against persons or property for the purposes of achieving a political objective within Canada or foreign state. There's also a few other categories. You're aware of that definition?
I am.
Yeah. And Ms. Thomas, you testified in front of the public order inquiry before Justice Rouleau, and obviously you were subjected to cross-examination by a number of different counsel.